I think we're going to get started now. It's 8:31. People are starting to log in. For those of you who don't know me, I'm Chip Gibbons. I'm the Policy Director for Defending Rights and Dissent. We're an organization that has, since the McCarthy era, fought for the right to know and the freedom to act. We are very pro-free speech. And as a result, we've organized a number of protesters for whistleblowers, for free press. We organized the first protest in the US calling for Chelsea Manning's freedom at Quantico, Virginia. And we are continuing to fight for the freedom of all people who are imprisoned or faced with government repression for the crime of telling the truth. I've also written several articles on the matter. An article in these times entitled "The Persecution of Chelsea Manning and Julian Assange" is about defending the US empire. I cannot take credit for that title. Journalists seldom get to pick them. I believe it was Sarah Lazar, who's an excellent reporter, whose work you should check out, an editor who did that. But I think that's really what we're talking about tonight, is that Assange and WikiLeaks leaked information that the public has a right to know about what our government is doing overseas, what crimes it commits in our names, with our taxpayer money, with our, in our name. Some of you may have seen there's really bad news tonight. It broke just about an hour ago. Chelsea Manning, who has been imprisoned in a detention center in Virginia for not cooperating with the WikiLeaks grand jury in Virginia, has been hospitalized. It's being reported that she has attempted to take her own life. As many of you know, Chelsea Manning was held in terrible conditions during her court-martial. She was subjected to conditions that the UN found to be possibly torture. The current Special Rapporteur on Torture has also expressed concern on her current conditions. To sort of re-victimize a torture survivor like this is horrendous. It's also even more horrendous because it's part of a larger plot to silence people who tell the truth. Chelsea Manning has long been a personal hero of mine. I remember a protest, Dan spoke at it, outside of Fort Meade, where we put Nobel Peace Prizes on the gate for her. And I still remember Dan's speech that day, and every time I write about her case, I go back and listen to it again because it was such a poignant and powerful speech. Chelsea Manning really embodies, who is a whistleblower, who is a truth teller. In a prolonged military occupation like what we saw in Iraq, dehumanizing the enemy is part and parcel of it. But from all accounts, Chelsea Manning continued to see the Iraqi people as people and wanted us to know what asymmetrical warfare looked like in the 21st century. And that's really what both these persecutions and prosecutions are about. Tonight we have Daniel Ellsberg, who has been a longtime advocate for whistleblowers. He leaked the Pentagon Papers to the press, which revealed decades of deceit by our government. We also have Kevin Gosztola, who is the managing editor of Shadowproof and was in London to cover the Assange extradition proceedings, one of the few US journalists to do so. He also covered the court-martial of Chelsea Manning when that happened, and the sentencing of Reality Winner. So he has a long history of reporting from the front lines of the war on whistleblowers. Dan is going to speak first, and then Kevin's going to speak, and then we will take questions in the chat box on the side. This event goes to 9:30. We got started right on time, so we will probably end right on time as well. Take it away, Dan.
We're going through a dark period for justice in Britain and America. After all, our civil law, our law in many respects comes from Britain, common law tradition. Even the rights tradition, they didn't have a Bill of Rights, but many of them were inspired by Britain to a large extent. And this shows the depths to which really this jurisprudence has come down. Nils Melzer, the rapporteur, the UN rapporteur for torture and abuse of other kinds, has said in both cases of Assange and Chelsea that he's looked into, that their death would be essentially a death by torture. that the conditions under which they've been held, each of them, one in England, one in America, amount to torture and amount to violations of the Geneva Convention, the ban on torture, which both the US and the UK are subject to. But of course, his comments have been ignored by both governments. And today we've come, you're telling us now, as you know, just you told me minutes ago, but an hour ago we learned in effect that one of these heroes may have been, we don't know what her condition is right now, but driven to death, let's say, by torture-like conditions. If she were to die, and I noticed that Assange's mother is rightly concerned about coronavirus in the Belmarsh prison where Assange is. I think the same would probably apply to Chelsea. The question of how coronavirus is being curtailed or averted in those conditions, which are very bad conditions. And of course, in both cases, almost certainly their immune systems have been compromised by years of imprisonment, including solitary confinement. So as Julian's father said after visiting him, there's real danger of his life. And 100 doctors who have not seen him personally, but have seen descriptions of his symptoms and his conditions, agree that he is in danger of his life. And now we're hearing that Chelsea Manning may be in danger also at this point. So I feel very emotionally about this. When Chelsea Manning's revelations came out, they were the first, I saw them as the first time in 39 years, since 1971, this was 2010 now, that someone had done what I did, in the sense of releasing a large amount of what amounted to documentation. In her case, videos and digital files didn't exist in my day. My day, 7,000 pages of top secret documents. But I'd been asking and waiting for decades now, given that the release of the Pentagon Papers is held, even in some court proceedings, as having arguably shortened the war or contributed to shortening the war, that people would, in the process of our endless wars now, would feel that that was worth risking their freedom for, risking their careers and their clearances for. And it had to be done in large scale to be convincing and with documents. And it just didn't happen. And I'd virtually given up on that until Chelsea Manning. And then with the help of Julian Assange. So as you say, Chelsea is a outstanding example of a whistleblower. Julian's organization, WikiLeaks, and Julian himself are enablers of whistleblowing. They're publishers of whistleblowing, without which the whistleblowing could have no effect. After all, Chelsea had offered her documents and videos to the New York Times and the Washington Post, and talked about them both, and neither of them showed any interest. It was when she turned to WikiLeaks and got it out, got the collateral murder video out. And probably I find many of our listeners have probably not seen that collateral video murder. They can get it on YouTube easily, just say collateral murder. And that was a very apt name, although Assange was criticized for it at the time. It's not just collateral damage, and it's not just collateral death. It's collateral murder of unarmed civilians in a way that was absolutely justified or called for investigation, prosecution. And in this case, they had the video, near certainly conviction for a wartime atrocity, killing of unarmed civilians, including, as you say, 2 Reuters journalists, and the wounding of 2 children who were in a car. Their father was trying to help the victims, and that was sprayed with bullets as well. So in the case of Assange, very briefly here, yes, people have said the conditions under which he's being held and the very fact of the extradition, he's being held for this, is a strong deterrent to journalists to publish truth. As you say, to publish truth that the government doesn't want told, truth that is classified precisely because it reveals crimes like collateral murder. Chelsea, with the help of Julian, revealed not just that instance, but hundreds of cases of torture of Iraqi prisoners, civilians in most cases, being turned over, captured by Americans and turned over to Iraqis with the knowledge that they would be tortured. And that knowledge makes the Americans at every part of the chain of command up to the commander-in-chief, which included Barack Obama in those testimonies, preceded by George W. Bush. Complicit in a crime as serious as torture itself. In other words, failing to investigate, failing to prosecute, and to stop processes of torture is a crime on the same level, and that's the highest level of international law. It's, by the way, what's called a non-derogable law, which means that a legislature or parliament cannot make torture legal. Like piracy on high seas, kind of an anachronism there. Well, not, I guess, it does go on now. But genocide, for example, it cannot be made legal by an act of Congress or anything. And yet, as we know, Kevin knows, I think the one person prosecuted who was in any way knowledgeable about torture and was not involved in it directly was John Kiriakou, who revealed the name of a torturer. And he spent time in prison for that, no one else. I think the main reason for, but I think it's not only the deterrent effect that they're interested in the US government here. They also do want the extradition, I believe. They wouldn't mind, because the extradition will take years, almost surely, with appeals. It's a long process. I'm sure that the US government, to generalize here with some, no doubt, individual exceptions, would be glad to see Julian Assange off their hands by death in prison, whether it's by coronavirus or some other reason. They'd be happy. I'm sorry to say this, but they could live with Julian's death through suicide or any other means, and get him out of the picture. But ideally, they do want him extradited, to believe, to be held on trial here as the first journalist to be tried under the Espionage Act or any other law for being a publisher of classified information. Now, he's a perfect person to start that process with, and he would be the first, though they've thought about indicting other people, but he would be the first actually indicted under that law. I was the first former official, to be indicted for disclosing classified information. There have been, under Barack Obama in particular, 9 or 10 people indicted for that, more than all previous presidents. But the Obama administration did consider indicting Julian Assange and backed off from it. It would be such a blatant violation of the First Amendment, freedom of the press, with the press being the only profession protected by our Constitution, basically, not doctors or lawyers or anybody else you could name. The press, for the purposes of preserving a republic and a democracy, are specially protected there to get information of the kind that Julian Assange is charged with revealing, and Chelsea Manning was charged and went to prison for it. So they say that's such a blatant violation to indict that the Obama administration, which indicted more sources than all previous administrations combined, in fact, 3 times as many. It's a small number because of the First Amendment, but they indicted 9 or 10, if you count Petraeus, I believe, compared to 3 earlier in earlier administrations, of which I was the first back in 1971. And my trial was dismissed for governmental misconduct at that time. Okay, if they extradite Julian Assange eventually and get him here and try him under the Espionage Act, I'm afraid in the present mood since 9/11 and the present court, which the Supreme Court has never addressed the question of whether such a prosecution would be constitutional. In my day, I can say from lawyers who wrote at the time, like Mel Nimmer, it was be blatantly unconstitutional to do that. Can we count on the present court 5-4 to reach that? No, we can't. In any case, at the district level, he would almost surely be convicted, especially in the Eastern District that he would be tried with in Virginia. And he would be convicted I think he would be held under conditions under which he's now being held for the rest of his life. And he would not be the last. He would be the first. And under this administration, even, there would be time. Well, Trump won't get him in this term, won't get back in this time. Frankly, if Trump is replaced, we can't count on whoever replaces him, Democrat, to hold back from pursuing this prosecution, even though Obama did draw back from it. But Hillary Clinton's comments at the time were, indicated that she would be totally in line, I think, with prosecuting a journalist, I believe. She's not a candidate now, but if that's true of her, as I think it is, and John Kerry later, it would be true probably of others. And that would lead to immediate prosecution of other journalists, some of whom would, like Chelsea, go to prison rather than reveal their sources or rather than, go along and cooperate with the government of that, but not many. And it would put a deep freeze on investigative journalism, in particular of the national security agencies, so-called, but defense, so-called. At 88, I'm really beginning to, I worked in the Defense Department, but let's call it the Department of Offense, the Department of Empire, whatever, the Department of, defense is ridiculous. It has almost nothing to do with defense of the United States of America. There's some exceptions to that I could go into, but generally that's not what it's been operating at for the last half century. And that's why its operations have to be secret and not revealed by whistleblowers. So without a press, then, I would say the unauthorized disclosures, which are, I've called, the lifeblood of a republic, will be cut off. And as everyone knows, under Trump in particular, a republic, a democracy, a democratic republic, small letters, is endangered day by day, week by week, another 4 years, all the more. But with the use of the Espionage Act confirmed to cut off all leaks, there just won't be a pretense of being a republic anymore. So that's what Chelsea Manning is protected with her life in jail right now, protesting it, and it's what Julian Assange is facing trial for. Okay.
Kevin is up.
I'll want to start by responding to the news that broke because I'm actually about the same age as Chelsea Manning, and I would like to say that she has more courage and strength than I think I will ever have. You know, what she's endured and what she has done in this grand jury case is hugely significant in terms of setting a standard for grand jury resistance, for challenging the way that grand juries are abused and used against people who are activists or dissidents in the United States. The way in which she has taken a stand on behalf of press freedom. She's been very clear about why she is going through this. We're coming up on a year that she has been in jail in some form. There was about a week of time in between where the grand jury elapsed and then it was empaneled again. They resumed a session. And so she's in there until the 18 months is up for this current grand jury. And I theorize, and I think what we've seen in the last week, because we have evidence from her attorneys, that she was summoned to go before the grand jury, even though she still maintains her resistance, that she was summoned to go before the grand jury. And that was before she attempted suicide. We can tell that the prosecution is thoroughly frustrated that they have not been able to force her to testify before the grand jury. And the reason why they are pushing so hard to have Chelsea Manning testify is because her timeline of events, this is important for people to understand, her timeline of events from her statement that she read in a military court at Fort Meade in February 2013, when she pled guilty to some offenses, is not the same as the timeline of events that the prosecution is putting forward when they make their allegations against WikiLeaks founder Julian Assange. They believe that Julian Assange recruited Chelsea Manning to steal documents on behalf of what, and these are not my words, this is how Secretary of State Mike Pompeo has described WikiLeaks. He says they are a non-state hostile intelligence agency. And so he has acted as if this organization was recruiting Chelsea Manning within the US military to go about the secret networks of databases and steal documents. And they specifically cite something called the Most Wanted Leaks List that was promoted by WikiLeaks in 2009. But what's important to understand is this was a collaborative list between activists and journalists, human rights activists, people who are from nonprofit organizations who put documents on the list from, I believe, around the world. These were documents that they believed needed to be disclosed, and people needed to do the work through activism to force transparency from these governments. And so they argue this was a roadmap, this was a guide, but this didn't work when they were arguing against Chelsea Manning at trial. This quickly fell apart when David Coombs, her defense attorney, picked at it. And it will have the same success in this case, because the only thing on that list that she released is an Iraq Rules of Engagement file. Now, why would she release the Iraq Rules of Engagement? The reason was not because she saw it on a list that WikiLeaks was asking her to provide. She sent it with the collateral murder video that Dan was talking about so that WikiLeaks would have context and could show that rules of engagement were not followed by those soldiers in Baghdad when they fired upon innocent civilians, when they fired upon journalists. And so this is a key. They need to find a way to get Chelsea Manning into a courtroom, well, not a courtroom, into this room where they hold these grand jury, these extra legal proceedings. They need to drag her in there, find a way to impeach her credibility, get her to backtrack, stumble, have trouble recalling events. Let's keep in mind, this happened 10 years ago. The passage of time is an important aspect of this case. It should be a barrier to continuing forward with this case under the Espionage Act. But so far, that hasn't stopped the prosecution. But it's certainly, I think, an element because Chelsea Manning can't possibly have all the details straight. They want to ask her about chat logs and when she sent what on what date and at what time. And do you remember what happened here? And do you remember what happened there? And they want her to fumble and bumble so they can catch her and attack her credibility and make it seem like they have the right timeline of events. And in fact, what she said was, and these are the words that I heard when I was in London from the prosecutor who is working for the Crown Prosecution Service to have her extradited to the United States. They were very frustrated with Chelsea Manning. And they said that her statement is a self-serving statement and the words of a co-conspirator, someone who has worked constantly to further the agenda of WikiLeaks. And they still believe that she is working as some kind of recruit for Assange while she is incarcerated, while she is jailed right now. They believe that all of this resistance is something where she's still a pawn of WikiLeaks. That's the way they describe this. I'll just quickly, I want to get to questions and answers. I want to get to the Q&A part of this webinar because I think it's important to hear from people. But let me quickly outline the charges just so people are aware. There are 17 Espionage Act counts that were issued in May. The first charge came in April when he was expelled from the Ecuador embassy. All of them are technically Espionage Act charges. The 18th charge, the one that people say is a conspiracy to commit a computer offense charge or a computer crime, is written like an Espionage Act charge. I mean, Dan will know exactly what I'm talking about because it's related to national defense information. You can find that language in this charge. He's talking about committing a computer crime, but in the process also violating the Espionage Act. It's a computer fraud and abuse allegation that it's masquerading as a computer fraud and abuse allegation, but it's really just an Espionage Act charge. The nature of what they are doing, it's important to understand, is they are seeking to impose secrecy law on an Australian. They are seeking to impose secrecy law on someone who is not an American. They are saying that they can enforce this on people who do not have any allegiance to the United States. There is no reason why they should be expected to obey the United States government. And this is very dangerous because the signal that is being sent, if this goes forward, threatens anyone who would engage in journalism throughout the world. I myself, as an independent journalist, anyone else who would travel to a location and report on another government and obtain documents from another government could potentially be vulnerable to extradition if they committed an act that government viewed as seditious, treasonous, somehow an act of espionage against them because they believed they worked with a leaker or a whistleblower, or let's be clear, a source. Their source was someone that they were seeking to criminalize, and they also would like to criminalize the journalist for publishing information from a source. So let's say, we can imagine the list of governments that might have the power to do something like this. It could be Australia, because we've seen a decline in the way that they protect whistleblowers in that country. It could be the Israeli government. It could be Saudi Arabia. It could be China or Russia or Iran. It could be Brazil. We already saw with the effort to try and indict Glenn Greenwald that those allegations and the way in which they almost brought that forward against Glenn Greenwald seemed very, very similar to what they are trying to bring against Julian Assange. I want to say very quickly about the arguments that I heard while I was in London, that the main part of what the prosecutors are arguing to try and save Julian Assange from extradition involves something called political offenses, and saying that he is accused of engaging in a hostile action against the United States that was basically a counter or a way that he was attacking the United States interests. And the way that they phrase this, the way that the indictment is written is an indication that they are criminalizing somebody for challenging the United States government. And that makes it a political offense. And so the act of what he engaged in may not necessarily be recognized in countries around the world because it's unique. It's a bunch of officials deciding that they want to pursue somebody for basically engaging in a political act against the US government. And so they are trying to argue that under the United States and United Kingdom's extradition treaty that we have with each other, that Julian Assange should not be extradited because there's a protection against being extradited for a political offense. So the obstacle here is trying to convince the judge that, in fact, this is the case. And I will close on a very similar note to what Dan ended with, which is to say that we are in a very bleak time, even with Donald Trump maybe having the possibility of losing in 2020 in November, with maybe a Democrat taking power. There is absolutely no guarantee that this would change everything. Unfortunately, while President Barack Obama's administration went up to the line and did not cross it and indict Julian Assange, what they failed to do is shut down the grand jury. And so it laid dormant, and it was there and available for Attorney General Jeff Sessions to reawaken this sleeping giant and turn it on people within WikiLeaks. We don't know if it stops with Julian Assange. We don't know if it involves other people associated with WikiLeaks. But we also have seen people indicted under the Espionage Act by Donald Trump. We have seen Reality Winner be prosecuted for providing a document that she believed showed evidence that the Russians targeted and interfered with voter registration systems. We have seen Terry Albury, an FBI whistleblower, go to jail for providing documents to The Intercept as well that were about the way FBI recruits informants, the way that they go after confidential human sources. We saw that they also are about to put on trial Daniel Hale, who is this alleged drone whistleblower who provided documents. Again, we're also talking about the Intercept, someone who gave documents to journalist Jeremy Scahill. And so in all of these cases, it's very clear that there is an open assault on press freedom and an open assault on people's ability to be exposed to information. Fortunately, we've seen a setback for the government in New York, where they tried to go after Joshua Schultz, who they accused of leaking the Vault 7 materials to WikiLeaks. That could have been a huge trial, putting things on the record, convincing the judge of a jury of certain aspects related to WikiLeaks, but they couldn't prove that he was actually the leaker, so that was a mistrial. And to end here, Joe Biden, back in 2010, called Julian Assange a high-tech terrorist. We don't know that Joe Biden's attitudes have changed at all. We don't really have any reassurances that a Biden administration would treat this differently, would shut it down, because we've seen this game played where they say they're opposed to the Espionage Act offenses, but they're okay with prosecuting Julian Assange for the conspiracy to commit a computer crime offense, which means that he would still be extradited to the United States, which means he would still be put on trial.
Thank you very much, Kevin and Dan. We're going to take questions now. We have about a half hour for questions. There's a Q&A box. You can type your question in there, and I'll read it to the two panelists. I see some of you are putting your questions in the chat box. You can do that as well. We already have 3 questions, but I'm going to abuse my prerogative as the moderator and ask just one question, and it's for Kevin. You were in the extradition proceedings in London, and you mentioned to me that they had a lot of revelations or impact for U.S. global spying around the world. Could you tell us what we learned about U.S. global spying around the world from the Assange extradition hearing you were at?
Yeah, you're referring to the Spanish security company that was tasked with or hired, we now know, given a contract by U.S. intelligence. Actually, it's interesting. We learned from reporting, I think it was first in the New York Times, but highlighted by the defense team for Assange, that David Morales, the owner of Undercover Global, traveled to Las Vegas for a security trade fair and was granted a contract from Sheldon Adelson, the Republican billionaire known for bankrolling many, many Republicans, giving lots of money to Donald Trump for his election. And he was given a contract. And around the same time, Morales got a contract with U.S. intelligence, some aspect of the maybe the CIA. We don't quite know, but just vaguely U.S. intelligence. We know that he was tasked with doing some work, and he went back, and there was a relationship established, and the company, on behalf of the CIA, was feeding back data to the U.S. government so that they could access photos, video, contents of conversations between people who were visiting the Ecuador embassy. And this was a part of an effort on by the Ecuadorian government, the right-wing government of Lenin Moreno, to engage in a pressure campaign against Julian Assange to revoke to basically go back on political asylum and get him to go insane and force him out of the embassy. They made a mockery of granting political asylum to Assange by doing this. And people who were visiting, journalists were targeted, Americans, they were also interested in Russians because of what we had heard in the media about how, maybe there was a role that was played there with, and again, just to be clear here, Julian Assange has maintained that he never got any information from a Russian state actor related to those emails that were about the Clinton campaign back in 2016. So I just state that for the record because that's what Julian Assange represented. And so they targeted journalists. They tried to steal Washington Post reporter Ellen Nakashima's phone battery. They were trying to plant malware on people's phones in order to use them as tracking devices. And so this was the extent to this operation. And legal team meetings were being held in the women's bathroom because they were trying to escape this surveillance. And yet that didn't matter because there was still a microphone planted there. We hear that they took the microphones and they were uploading data to servers that were then accessed by the CIA. And here, this is where it gets worse because we know there are whistleblowers that are going to be testifying in an upcoming hearing, this 3-week hearing that is going to be happening from May to June, where witnesses will be called. We're going to hear from anonymous whistleblowers related from this company who are going to speak about how the people at UC Global, particularly David Morales, were discussing extreme measures to go after Julian Assange, talking about kidnapping him, leaving the door of the embassy wide open accidentally. I put that in quotes, accidentally, so that people could go in and snatch him and take him out of the embassy. Considering giving him some kind of poisoning him while he was in the embassy. This sounds like the kinds of things that are reminiscent of how the CIA targeted Fidel Castro. We can imagine, the two things I've described, I know these are what were talked about in the courtroom, but apparently it wasn't just limited to those two ideas. There were other measures that were talked about. And we're talking about assassinating potentially a journalist, somebody who is a journalist. He has a International Federation of Journalists card. He's a member. He's also a member of a trade union organization in Australia for journalists. He's a journalist. So that's, to answer your question, that's what we're talking about with this UC Global. It's a massive espionage operation that was targeted. It's flown completely under the radar. El País, the Spanish newspaper, is probably the only outlet that has truly covered it. When it was first covered in the US press, it was actually spun in a wrong direction. It was used to, as part of a narrative by CNN to try and bolster this idea that, okay, hey, we finally have our proof that there's some Russian conspiracy going on here with Julian Assange and WikiLeaks, and that he was using the Ecuador embassy as a hub for this. But there's just no evidence, and that's not even what those documents prove. The documents prove that there was an espionage operation against Assange and his legal team.
Thank you very much for that, Kevin. We have a bunch of questions now, both in the Q&A box and the chat box. There's also a large number of people watching on Facebook Live. If you have a question and you're watching on Facebook Live, please type it in the Facebook Live chat box, and a Defending Rights and Dissent staff member is monitoring that chat box and will get the question to me. The first question we have comes from Martha. Any comments about the pardon of Navy SEAL Gallagher and the impact?
Who's that to?
Anyone who wants to answer it.
Okay, let me
go ahead, Dan.
If I may. Look, I mentioned earlier the question of atrocities, war crimes in connection with collateral murder. Now, I was the training officer for 3rd Battalion, 2nd Marines in 1955, I guess it was. And I was also a company commander and a platoon leader in a number of platoons. But I was in charge of training, as I said, for some while, and that included on the laws of war. No question in my mind at all that, of course, the collateral murder was murder of a civilian, murder of a number of civilians was murder. What was alleged against Gallagher was, in the end, he was convicted only of a quite minor crime, in effect, of posing with a dead insurgent that they had gotten. But actually, the charges against him by a number of his fellow special forces officers, or rather enlisted men, was that he had wantonly shot at civilians and had murdered this particular civilian not civilian, but I think a 15-year-old boy, 15 or 16, whose throat he had cut. Those were the charges that they said. Now the jury apparently wanted to, preferred to believe or chose to believe contrary testimony on that. Let me just say that having followed that trial quite closely and the subsequent statements and preceding statements by these special forces who were clearly jeopardizing their reputation, their status, their membership, perhaps even their lives by testifying against a fellow special forces officer, enlisted man, sergeant at that point. I believe them. And that means that he wasn't found guilty, but I believe that on the testimony as of now, not a member of the jury, that we're talking now about a war criminal, definite war criminal, murder. For the president to essentially pardon him, I believe, it wasn't just commuted, but at any rate stopped the prosecution, and in fact is said to have wanted Gallagher to appear with him at campaign posts as a war hero. I can say that this was intolerable to me as a former Marine infantry officer. And the idea that he is telling the entire armed services that this laws of war in this respect are not to be obeyed, are to be ridiculed virtually. He said, we trained him to be a killer and then we prosecute him for killing. He was not trained in the special forces or anywhere else to kill civilians. I can tell you that. And nobody in the armed forces was trained to do that, no matter what their role. And for the commander-in-chief to be saying that was an outrage to me as a former infantry officer. And I'm sure to very many other people.
Thank you for that response, Dan. The number one question we're getting, a number of you have asked it, is what can people do to help Assange? What can we do to help Manning? And one person also asked what can be done to help Reality Winner. I've put in the chat box the petition defending rights and dissent started with Fight to the Future to the judge in Chelsea Manning's case. And I know my colleague Sue Udry has also put the petition in the chat box that we have along with Roots Action to pardon Reality Winner. I'll turn over to Kevin and Dan if they have any steps you can take to help Manning, Assange, Reality Winner, or any of the other whistleblowers.
Were you asking me or Kevin?
Both of you. Would you like to start, Dan?
We'll know that.
So what I'll say is I think it's important for people to share reporting on Julian Assange's extradition hearing. The next phase is going to be in May and June. I will be back in London. My reporting should be widely available and people can share it. And of course, I'm not just saying that because I want to boost my work. I mean, obviously I want people to read my work, but get it from anyone. There will be a handful of journalists at least that you can trust and you can follow the work, the people who are digging into this case. But I'm saying that the way that we can really build people's awareness of what is happening, that's the first step to ending this and challenging what is being done with these extradition proceedings. I'd say as far as Chelsea Manning goes, the first thing I just want to mention, I'm seeing that people have shared the number to call the federal judge, the phone number for the federal judge, but people who are connected to Chelsea Manning say Do not do that. Do not call. This could be viewed negatively by the judge, and they don't want it to undermine her ability to stand before the judge on Friday and argue for mercy. We are seeking mercy from Judge Anthony Trenga. He has the ability to end this right now. It has been done before. There are cases involving people who personally describe themselves as anarchists, who resisted grand juries out in the Pacific Northwest, who stood before a judge and maintained that there is nothing that was going to coerce them into changing their position on resisting the grand jury. And that alone convinced the judge that it was not useful, that there was no longer a justification for keeping a person in jail, because no matter what, the government was never going to get that person to stand before them or sit before them and answer their questions. So there are people that have been released because they refused. So what we can do is continue to send letters showing support and solidarity. And I think, maybe beyond, I'm not in DC, but maybe beyond going and calling the judge, maybe it's better if people are there on Friday outside to show their support and hold some kind of a public demonstration so people can see the fact that there are supporters and that people do protest what's happening to Chelsea. As far as Reality Winner, it's important for people to sign that petition for the pardon. That's really where things are at. And that is the focus going forward. That will be what makes the most difference. And there are things that the legal, there are things that her mother are trying to do in order to get the attention of President Donald Trump. Creative things that are being tried, perhaps. But what we can do is continue to ask people to pay attention to her case and support this pardon.
I would also add in that Defending Rights in Dissent has done a number of visits on the Hill to educate members of Congress about the Espionage Act and how it has been used to prosecute whistleblowers and now journalists. We've been pushing for reforms to the Espionage Act, and there is a bill from Ron Wyden and Ruth Kahana, which would make it more difficult to indict publishers' information or non-former government employees under the Espionage Act. Unfortunately, it's a very good bill. I'm not saying it's a bad one. It doesn't go as far as we would like to see and make it more difficult to prosecute the whistleblowers, which we have specific legislative suggestions on how to do that, but I will not get into them on this webinar because they're very wonky and legal. Dan, do you have any thoughts on how to help Manning or Assange?
Kevin?
Do you want to answer the question, or do you feel like it's already answered? How can we help Chelsea Manning and Julian Assange?
Pardon me, are you asking me, hasn't Kevin, I thought, very eloquently answered it?
Yeah.
Making people aware of the real issue. Okay. And Kevin has done a brilliant job of that today and always. Every time he speaks on it, I learn something. He's a fantastic investigative journalist, and of course that was a very eloquent statement. On the issues here, if I may say, Kevin, I saw a couple personal angles that were interesting to me. I didn't realize, for example, I'd never heard of this leak, this proposal for leaks that came out in 2009. That's a terrific idea. He's charged with it, but it wasn't invented in 2009 when former CIA analyst Ray McGovern and I, not in the CIA, in the Defense Department and State Department, we formed a thing called the Truth Telling Project back in 2004, I believe it was. And among other things, we called for people to do whistleblowing, to do leaks. And part of that, I well recall, we put together a list of wonderful leaks that needed telling at that point. I don't think we had on that the rules of engagement, but that would have been a very good thing to do. So if he's being charged with that, then let me remind the DOJ that that's all on record now, and that was a very good idea, I thought. One other thing, my co-defendant, Anthony Russo, not alive anymore, was brought before a grand jury to testify against me, refused on the same principles as Chelsea Manning, that this was a secret proceeding, a kangaroo court kind of thing. There was in particular at that time in '71 quite a movement against grand juries as undemocratic, and people in the movement in general were advised and did refuse often to testify against an institution that they felt was not a good element of Anglo-American jurisprudence. It was very common. So he refused to testify and was jailed for contempt, just like Chelsea. But after a month, it was clear, by the way, he was not going to change his position. And they let him out in order to indict him on that. And he was indicted along with me. Earlier, they hadn't planned to indict him. So also, he was not an official. He was not at the time we copied the Pentagon Papers subject to a security clearance, as I was. And so he really was the first person tried under the Espionage Act until Julian right now, who was not being tried as someone who was subject to an ongoing or even an ongoing clearance procedure. And had he been convicted, and the trial was stopped because of government misconduct against me in particular, had he been convicted, that would have been the perfect precedent in 1973, long ago, for trying people who were not official sources, people like journalists. So what you were describing is in this, and you mentioned Reality Winner and the others, Daniel Hale, is clearly an ongoing campaign here that has gone beyond Obama's campaign against whistleblowing. And you said very well, if even Obama had not crossed the line to journalists, but with Assange now indicted, without being tried or convicted, I think you can be pretty sure that the next administration, whether it's Republican or Democrat, will use that precedent right now, however it comes out. And that, as they say, would be one more potential death blow to democracy here. So making people aware of those legal issues and constitutional issues, as well as the precise, one last thing, one of his other cons I know against him, as you say, the conspiracy thing, is encouraging Chelsea and trying to enable her to get information out. Well, I can say as a source who was charged, with 12 felony counts on this and so forth, in the ensuing 40 years, I cannot count the number of times that reporters have asked me for classified information, which I didn't have often, or I would have given it to them. But that's just a journalistic practice, absolutely right in the line of journalism. And I'm looking at a journalist right now, but if you haven't ever asked a source for that, Kevin, you will and you should.
Yeah. If I could just add something very quickly, Chip, and then we can get to a couple more questions before we wrap. I want to make a big point here, which was made by someone connected to the Pentagon Papers case, actually. Jim Goodall, the former general counsel for the New York Times, made this point to me in an interview that I did before the extradition hearing that just happened. And he made this point that what the US government is trying to do is prosecute Julian Assange under the Espionage Act, but deny him the rights that would be attached to being prosecuted under a US law. And what I mean by that is they are saying that Julian Assange has no First Amendment rights. Well, that can't make sense. How can you be prosecuted under a US law but not get the constitutional protections that come with being prosecuted under a US law? We really would like to hear the way that the prosecutors are going to make this argument. It's going to be very important to see what kind of inventive reasoning they have for this, because it doesn't seem like it could make any sort of sense. But what Jim was willing to agree with me on was that they're probably making this up as they go, and they never anticipated that they would get this far as the Justice Department is concerned, because they're in new territory in pursuing Julian Assange. So that's something for people to consider, that there really is no basis for what they're arguing, and it's going to be rather easy to see that they have a thin argument legally. Now, another thing that's going in Julian Assange's favor, I'll insert quickly here, is there was a ruling last year in 2019 by a judge who is actually someone who Jim knows, Judge Kodal, who ruled in this case that the DNC brought against WikiLeaks and Trump and the Russian Federation, but particularly this case that was brought against WikiLeaks ruled that the publication of those emails from Clinton campaign chairman John Podesta was protected under the First Amendment, that it was okay for them to publish hacked materials. The ruling is an amazing ruling. Go read it. It's a defense of the First Amendment. And if you read it, it very clearly articulates that Julian Assange and WikiLeaks were engaged in journalism. So I think that this is going to be a barrier and something that the prosecutors are going to have to overcome in order to successfully pursue this case.
May I say, though, listening to you, Kevin, you say it makes no sense. Actually, it makes a rather straightforward kind of sense. I'll tell you what they're saying. First of all, when you free yourself from the restraint on government of the First Amendment, which is Congress shall make no law, abridging freedom of the press, when you've pushed beyond that little frontier, the territories are wide open. Now, nevertheless, if they use that against an American, the American would obviously, the first line of defense, which should prevail, is that he's protected, or she is protected by the First Amendment. But what they're saying is, at least they'll argue that, and they'll be right. They may or may not get 5 judges instead of 4 judges to agree with them on the Constitution, but they'll have the argument. They're saying now that foreign journalists don't have that argument. So if you can extradite them or pick them up in the US, and a lot of them are in the US, you pick them up here and prosecute them, they can't even make that argument. They're not protected by the First Amendment. They're foreigners. So it means that they're under greater danger even than Americans would be. And okay, that's a very inventive, but pretty straightforward process. You're all at risk under us, guys.
So I also want to encourage people to read Kevin's work. He is probably the best journalist writing about whistleblowers and the Espionage Act. I also, like Dan, always learn something new when I read his work. And whenever I have a question about any case, I always ask Kevin personally, because he usually knows, more so than other journalists. We're about at time. We have a couple more questions I'd like to get to. We have one person wants to know if we think the period between leaks historically is because of the horrific treatment of modern whistleblowers, and if that's the reason why there's so much time lapse between leaks. Do we think that the horrific treatment of whistleblowers has been a deterrent on whistleblowing?
Well, sure. Look, if I can say, I was put under trial on 12 felony counts for a possible sentence of 115 years. And whereas given the jury, when we talked to them afterwards, I probably would not have been found guilty of most of those, but the instructions by the judge who was being offered to be the head of the FBI, if the trial was ended in good order, I mean, with my conviction, and that had been his childhood dream, actually, to replace J. Edgar Hoover when he died. I was likely to be found guilty, actually, at that level, though not necessarily by the Supreme Court. Now the Supreme Court is different. But the purpose, of course, of that trial was to deter other whistleblowers like me. I could ask, there was 4,000 pages of documents, 7,000 pages in all. It's not exactly right, but that doesn't matter. Thousands of pages of government criminality and so forth, and wrongdoing, lying. How often should the Pentagon Papers like case come up? How often should 1,000 pages be put out? Once every 40 years? Or once every 10 years? I would say circumstances justify a couple times a year, certainly not less than once a year, but 39 years passed. So their cooling effect on this was greater than I wished it was. And as I say, 3 years later, we had Snowden. Snowden in permanent exile now. I don't think he will ever be able to come back to the US under any president, because no president will defy the intelligence community, which will swear eternal vengeance against Edward Snowden for embarrassing them by revealing the crimes, the clear-cut, massive crimes of the NSA in its surveillance and the unconstitutional behavior. He will never be forgiven for that. So he's in permanent exile. All of that, including what we've heard about Chelsea and Assange, are of course intended to chill, and inevitably journalists are human. They're effective. They know what they're doing. It does chill. So the point is, it hasn't chilled to zero yet, and we are getting important leaks still, some of them being prosecuted, some not. And we haven't lost our republic entirely yet, or freedom of the press, but it is definitely endangered.
Thank you. So we're over time, but I'm going to take two questions at once. I believe they're both directed at Kevin. The first is from Kit, and it's, when next face the court, what will that look like? And the second question is from Stephen, and it's, in London, the US government is arguing there are 2 extradition treaties or laws, one of which does not contain an exception for political offenses. Please explain why Assange is entitled to the political offense exception. So first question, when do the extradition proceedings resume? And then if you could explain the political offense controversy.
Yeah, so the political offense issue, and I'm only representing my understanding of the defense's arguments. I want to make it clear that I am not a defense attorney. And I do not have a mastery of UK extradition law, but I think it's this simple. I don't think we need to overcomplicate it. The United States-UK extradition treaty is the basis for this extradition. You could not have an extradition without a treaty. The agreement is what means that we can have an exchange of people between our 2 countries. And so for the prosecutor that is working for the Crown Prosecution Service to argue that the judge should not base her ruling on this treaty because there is a UK domestic law that does not have anything in it about political offenses is clearly wrong, because what should speak more loudly is the agreement that exists between the 2 countries. And even in spite of what the United States was doing. So to give people a quick background here, I know we're up and it's time to conclude, but I think it's important to work this in. Around 2003, 2004, when this law was being drafted, the United States was going around to countries after the September 11th attacks, and they were lobbying governments to remove the political offense exception because they were afraid that there were going to be terrorism suspects who were detained, who were going to argue they were committing political acts of violence and that they were really struggling against governments. And so they were going to use this as a way to escape extradition to the United States. And, if they felt like they were struggling against the so-called US empire, that might have been something that the United States would be fearful of being effective in a courtroom. And so they moved to have certain violent offenses be excluded from this. I mean, it hadn't always been the case. I want to be clear. It has not always been the case that people who engaged in political violence weren't protected from extradition. We heard examples from the defense team of people who were involved in militias in Sri Lanka who had been protected from extradition because if they were sent back to Sri Lanka, they would be tortured by their own government. So the fact of the matter is that the judge needs to rely on the US-UK extradition treaty because it is just that simple, that the political offense exception is still in the treaty, and that's what should speak. Now, the next thing coming up is this witnesses hearing that we're going to have. Those are the next proceedings. It'll take place over 3 weeks. We are going to see witnesses come forward who are called. The defense has to put on their case. I believe it's the defense that has the burden to prove to the judge that Julian Assange should not be extradited to the US. And if they don't prove that, then she's going to sign off on the extradition. So they call witnesses to make their case. They're going to call journalists that worked on the leaks to show that Julian Assange was not reckless. They're going to call people who can speak and put what was done in context. We don't know yet for sure, but Noam Chomsky was listed as a witness, someone who is willing to give testimony. I have no idea. Given Noam's age, if he's planning to make a trip across the to go to United Kingdom and give testimony, we'll have to see what that means. But there are people on the list. There are attorneys from Assange's legal team on the list. There are people who are going to attest to his deteriorating mental health and why he should be shown mercy. He suffers from clinical depression and other issues that are very serious and need to be considered when deciding whether he should be allowed to be sent back to the United States. Well, not sent back, in determining whether he should be sent to the United States and put in a system that incarcerates 2 million people and is known for the cruelty of the way that it isolates especially high-profile prisoners like Julian Assange. So I conclude with that. And I guess I'll give you some ray of hope connected to what Dan Ellsberg was talking about. Because young people are naive naturally. Chelsea Manning is where she is today because she naively believed that she could change the world. And we're all happy that she took that step because we have over 1 million documents thanks to her because of what she did. We really have close to 1 million or more documents thanks to what she did. And the same with Edward Snowden, the same with Reality Winner, the same with Daniel Hale. These are young people who do not have fear yet. They do not know the way in which, they do not fully contemplate and understand the way in which the US government can bring the hammer down on them. And so they act. And this is something that government agencies are going to grapple with. This is something that private contractors are grappling with, that young people are the ones generationally who are changed. We're seeing the gap. We are seeing, this is reflected in the primary that is unfolding in the Democratic Party. It's reflected throughout the country that young people have a different opinion about how government, and I will plug, Tom Mueller has an excellent book that's over 500 pages. It's called Crisis of Conscience. It's about whistleblowers. It's a great chronicle, but primarily I reference it to say that we are in a crisis of conscience, and it is clear the extent of corruption. I mean, you can barely have an hour conversation and scratch the surface and get to 1 or 2% of what we're dealing with. And that is so overwhelming, and youth see it. And these millennials who staff government and private contractors are a real liability for the US government because they have access to social media, they share information with their friends, they talk, and they're not just going to go along with this corruption. I think that there are very many young people right now that are considering what they can do to expose information, even in spite of the way that the Espionage Act can be used.
I think that's a really great note to close on, a hopeful one. I want to thank both Kevin and Dan for joining us tonight. I want to thank everyone who joined us either on Zoom or Facebook Live. I know there's a number of people watching on Facebook Live, and we will follow up with an email with more information about how to get involved and also how to read Kevin's work because it's really a must read. Thank you so much to our panelists, and thank you so much to our attendees. Have a good evening.